A deal memo is a preliminary agreement typically used to outline the basic terms of a deal before a final contract is signed. The problem comes in when people treat a deal memo like it's a done deal, and it's not. The outcome of a deal memo depends on the state that you live in. For example, in Georgia, if you live in Georgia, or if the deal memo is created in Georgia, and the law that governs that deal memo is Georgia, then a deal memo is generally not enforceable unless it satisfies the essential elements of a contract formation, meaning that it has to include the parties to the contract, consideration, money or performance. It has to have the agreement to all material terms, and it must have a clear subject matter. If the deal memo leaves material terms open, a Georgia court is likely to say that there's no binding contracts, and the courts have held that an agreement, a deal memo that leaves material terms open, is an agreement to agree in the future, and it's not enforceable. California takes a different position. California courts recognizes a contract to negotiate, meaning if the deal memo is drafted in a way that the parties agree to negotiate the final terms, they can be bound to negotiate in good faith even when the final terms are not yet settled. If one party walks away without attempting to negotiate in good faith, then there can be liability. But if both parties negotiate in good faith and they still can't reach a final deal, then no other obligation exists. Even with that type of deal memo, there still needs to be mutual agreement on all material terms to become a binding contract. Now, New York recognizes two types of binding preliminary agreements. The first type is where all essential terms are settled and the parties intend to formalize that into an agreement in writing. The second type binds the parties to negotiate any open terms in good faith without requiring a final deal. But still, even in that case, if material terms are left open with no objective method for filling them in, a New York court may still call it an unenforceable agreement to agree, not an agreement to negotiate, and it won't be enforceable just like Georgia or California. A deal memo drafted without mutual agreement on all material terms is a common thread through most states. It's a starting point, not a finish line. Knowing what state law governs your deal memo changes what can be enforced and what cannot be enforced. If you have ever heard someone say that they have discussed an opportunity and completed a deal memo and they assume that the deal was done without signing a contract, share this video. I do not give specific legal advice in DMs, the comment sections, or make personal calls. If you want specific guidance or consideration for representation, please read the description below on how to proceed with investing in your protection. Otherwise, keep learning from My Attorney Knows educational videos with the Ownership Attorney.